morning, everyone. This is attorney Devin Shanley with Peterson, Berk, and Cross, broadcasting to you live from my office for another edition of Lunch with the Lawyer. Today's topic is what is a guardian ad litem? A personal topic to me because I am a guardian ad litem. It is an area of practice that I love. Regular watchers know, I think I've mentioned that before. But before I get into that, a couple things to talk about with our format today. And I've got a lunch sponsor today. So today's lunch is brought to us by Stadium View over on Holmgren Way. If you get a chance and you're in the Green Bay area, or you're not, you're just traveling through Green Bay, make sure to stop there for your eating desires. Today I ordered the haddock sandwich. I got it right here. Look at this lovely bun. It's a pretzel bun, which I always love, and I'm always a sucker for a good fish sandwich, which this is. Probably should have taken a smaller bite, but they are open for dine-in. I walked in, I picked it up. There are some people at the bar, some people ordering. The staff is phenomenal. The food is excellent. So if you're in the area, Stadium View over on Holmgren, keep it in mind. Also, for events, if you're hosting an event, say a wedding, once we can start to have mass gatherings, keep Stadium View in mind as well. They have a very nice banquet hall. So again, thank you to Stadium View this week. Format for our discussions today is going to be, well, first of all, I told you about my lunch, the wonderful haddock sandwich. Please, if you're watching live, feel free to comment about what you are having for lunch. I'd love to know. Even if you're watching this later at a different meal, and you're going to comment later and say, "I'm having cereal with this, Devin," I will respond, and that will be awesome. So again, keep us in mind as you're doing this. Feel free to participate. On participation, the Lunch with the Lawyer segment I like to keep as informal, talking about the law, helping people be familiar with general legal concepts, and giving a chance for you, the viewers, to ask questions of an attorney. A lot of times people don't have that opportunity, or they're afraid to because they're afraid of the answer, or they're afraid it's going to cost too much. One of my favorite activities actually is I sit down with one of my wards as a guardian ad litem, and we'll talk about that in just a little bit and what I mean. But one of the kids that I work with as their guardian ad litem, and I look at them and I say, "How much do you think someone pays for an attorney?" And the kids are mystified. They think that there's a lot of money involved, but they don't really have a clear concept of what a lot of money is. And they say, $50 an hour? Or how much do you think I would get paid an hour? They're like, $50? And at that point, if the parents are in the room at the same time, they almost laugh, going, "I wish I was only paying my attorney $50 an hour." So, guardian ad litem, with Lunch with the Lawyer, I lost my train of thought. Lunch with the Lawyer, this is your chance to be able to ask a question to a lawyer for free. I won't give legal advice, and I don't want to ask for any particular situation. Oh, Megan has Kraft macaroni and cheese, and that's awesome. I will say this. My kids love Kraft mac. We can buy the fancy mac and cheeses, and I don't know if anybody else has seen this, but my kids will just eat the Kraft one. I can get super fancy, perfect mac and cheese, Panera mac and cheese. No, it's got to be Kraft, and they'll make me pay like $10 to have restaurants make Kraft macaroni and cheese too. Anyways, a lot of times what I find is people are afraid of the cost. This is a chance to do that. Now, I will only be answering questions about the law, not certain fact scenarios. That would actually constitute legal advice and would bind an attorney-client relationship. So we don't want to do that, and that actually becomes important for what we'll be talking about later as well. So we'll be sticking with hypotheticals, but we can give you feedback and can give you an understanding. And if you do like the presentation today and you do want to learn more, or you really want to ask about your specific situation, please contact any one of the attorneys here at Peterson, Berk, and Cross at 920-831-0300, or you can contact us through the Facebook page. You can contact us through our website, foxriverlawyers.com, and we will get back to you. We will try to help you out because at Peterson, Berk, and Cross, we're specializing in you. Without further ado, though, What is a guardian ad litem? This is a question I get a lot. Either when I sit down with parents for the first time when I'm actually appointed as their guardian ad litem, or when I'm representing somebody in a family case and I casually put that out and they go, oh my God, a guardian ad litem, how much is that going to cost? What do they actually do? And people get really scared because people think they hear guardian ad litem, it's a Latin term, they don't really understand it, and it's just really, really scary. So, what is a guardian ad litem? A guardian ad litem is an attorney, at least in Wisconsin. Not every jurisdiction has that, not every single state, or even sometimes in Wisconsin, there are separate pocket jurisdictions, most notably Native tribes, where they have their own family court system, and they set their own rules for what a guardian ad litem is, and sometimes it's not an actual attorney. But in the state of Wisconsin, if you're in a state of Wisconsin court, then it is an attorney. The attorney is appointed by the court to represent the child's best interests. This involves investigating the child's best interests. But what does that mean? That's a good question. The best way I can explain it simply and quickly is what I tell parents early on, particularly parents when I'm the guardian ad litem and they've never worked with a guardian ad litem before. I give them what I call the 3 rules. The 3 rules, I say, this is to help us get along better, or at the very least, have me charge you less money. At which point I get a little cheap laugh from them and I move on to the 3 rules. The 3 rules operate like this. Rule 1, if I'm your guardian ad litem, I am not the court. The guardian ad litem is not the court. What do I mean by this? The guardian ad litem is in fact an attorney, just like mom's attorney or dad's attorney. That means the guardian ad litem holds no special powers. They don't make decisions. They don't give orders. That's the court. That's for judges to do. And judges have that responsibility. Guardian ad litems are in fact not the court. A lot of times people think a guardian ad litem is some sort of adjunct to the court or some sort of investigator for the court, that they're like the court's attorney / private eye going around getting information and doing this. And sometimes it kind of works out that way, but that's not really what the guardian ad litem is there to do. The guardian ad litem is there as an attorney. Their job is to advocate. That means their job is to represent something and to say to the court, this is what you should do, and this is why, based upon the facts and the law. Just like every other attorney in the case. They're just another party. They are not the court. What do I mean by this when I tell parents, I am not the court? I mean, if you're going to call me at 5 o'clock on a Friday and say, my wife should be here, and she's not, and all this, I'm going to say, thank you for telling me this. I will make a notation, and then I'm going to hang up the phone, and I'm going to charge them for that. So if they don't make this angry phone call, or maybe they just send an email, it might be less of a charge. Or they might get angry again and say, well, why did you do this? And why didn't you do anything? And I'll listen and I'll explain this and I'll go through the rules, and then I'll charge them to listen to them and explain them to go through the rules, and it becomes a vicious cycle of charging. Don't do that. Just remember rule 1, I'm not the court. If you're going to say, what are you going to do about that? The answer is probably make a notation and tattle on somebody later to the court, or form an opinion and maybe side against them, or maybe try to get them to cooperate, but that's going to be limited to, you really should, rather than I order you to do X, Y, and Z. So that's how that operates. So rule 1, the guardian ad litem is not the court. Rule number 2 is what I tell parents, I am not your attorney. The guardian ad litem does not represent the interests of the parents. This sounds very simple and straightforward, but in a court case, this is probably the rule that gets most violated. Just like early on when I said, I don't want to give specific advice to your case audience if you ask questions. I want to do on hypotheticals because I don't want to form an attorney-client relationship. That's not a very easy relationship to form. And the guardian ad litem actually is an interested party. That's going to be part of what we get to later. So the attorney really shouldn't give legal advice to the other party. Or if they do, that party needs to realize the guardian ad litem might be doing this more to persuade them to a certain legal outcome than rather advise them as to what would be best for them. Put another way, the guardian ad litem is not necessarily on your side. And really, in a very, very strict legal sense, they're not. A guardian ad litem is going to be an opposing party in a very hyper-technical sense. The guardian ad litem may align with you, they may agree with you, but they are not on your side. That's your attorney's job. How does this work out practically? The way Rule 2 for me is always violated is when parents come in and say, what do I do? Instead of the question of the court, what are you going to do? What am I going to do? I'm going to do nothing right now. I'm going to take a note. Maybe I'll make an angry phone call, but that's going to be it. If people say, Devin, you're my guardian ad litem, what do I do? Well, if I'm going to answer the question of what do I do, if someone's asking that of a lawyer, chances are they're asking for legal advice. Devin, with your knowledge of the law and our facts, what is going to be the best choice of action to get me the outcome that I want? Well, if I'm your attorney, I'll happily give that to you. That's why you pay me. If I'm your guardian ad litem, I probably don't want to give that to you. It's probably not appropriate for me to give that to you. If you're that concerned about what sort of legal advice you need, you should hire an attorney that has a responsibility to you. And if you have an attorney, then contact your attorney. We'll get this in a little bit. It's so basic, and I hate to say it, but a lot of times the guardian ad litem isn't paid as much as your normal attorney. So as much as you'd like to get free, good, or not free, cheap, good legal advice, that's really not an appropriate action. It's probably going to get on the guardian ad litem's nerves. If you have an attorney, ask your attorney. If you don't like your attorney, get a different attorney. If you need an attorney, find an attorney. Don't use the guardian ad litem in that fashion. That's not going to be beneficial. It's not going to form a good relationship between the guardian ad litem and you. It's not going to make you more persuasive to your case. And the guardian ad litem really shouldn't be getting into that. That's not their job. Rule 3. I am not neutral when I tell parents. The guardian ad litem is not neutral. And this ties in very closely with Rule 2, and also Rule 1. The guardian ad litem, as I stated, is an interested party. What does this mean? The guardian ad litem takes a side, makes a stand, puts forward a legal argument, and stands behind it, just like every other attorney. That is a great question from the firm itself. The question here that it just came up is who pays the guardian ad litem? I will be answering that in just a little bit. So when we talk about the interested party, it also raises the question, and this is a fascinating question to me, who is the client? The answer is no one, which is another reason why a part of me really loves guardian ad litem work. Which I hope, I see Attorney Schlemmer has commented, but if any other attorneys, especially guardian ad litems, do that, you might get a chuckle out of that. No one is the client. The client is this basic ethereal concept of the best interest of the child. If you want more information about that, go to the Peterson, Berk, and Cross website and look at last week's Lunch with a Lawyer, where I gave a very long explanation about best interest of the child, or contact either Angela, Stacy, or myself, and we'll give you another long explanation about what is best interest of the child, and we'll be happy to do that as well. But the guardian ad litem needs to investigate the best interest of the child and then form what they think is going to be that, and then stand behind that recommendation. They're there to kind of look out for that, or to put it another way, the guardian ad litem is going to be going to give the child's voice to the proceeding, not necessarily give them a choice. So a child, or this happens a lot in adult guardian ad litem situations, they might have it in their head that they want to have something, and the guardian ad litem makes a conclusion that that's not in their best interest. The guardian ad litem and the child could actually disagree. In different proceedings, you might actually have someone with a guardian ad litem and their own counsel, in which case, and those two attorneys disagree. The guardian ad litem could come in and say it's in the best interest to only be with mom. And somehow the child gets their own attorney who comes in and says the child wants to be with dad. That could technically happen. And the guardian ad litem's role and their ethical duties tacking to that concept of best interest really allow that to happen. And it emphasizes that the guardian ad litem is not neutral. They pick sides, and that side may or may not align with you. I had talked about who pays for the guardian ad litem, and then I got a couple others. So I'm going to deal with a couple of these questions. Who pays for the guardian ad litem is very, very interesting. The answer, so there's a joke in law school, is the correct answer to everything is it depends. So my answer of who pays the guardian ad litem is it depends. It'll depend primarily in the state of Wisconsin as to what county you're in and what's the local practice of that county. So what I would recommend is hire an attorney and ask the attorney what the practice is in that county. If they don't know, they should be able to find out relatively simple by asking other attorneys who do. Or you can contact the clerk of courts as well. Typically, I'll talk about Brown County and my own experience. I'll also talk about what I understand about a couple other counties. So who pays the guardian ad litem in Brown County? Primarily, guardian ad litems are appointed by having a contract with Brown County itself. So the court will appoint, they'll have a list, and they'll just kind of go down the list and say, okay, you're getting Devin now. And then I'll get a call that says, Devin, you have an appointment, come down and sign, which I actually have to go down and sign. So if someone's watching from Brown County Family Court Commissioner's Office, I'm going to try and get down there this afternoon. Once I sign, I have a prearranged contract with the county where they will pay me so much. It depends upon the type of case. They will require the parties to pay a deposit ahead of time. So it's usually an order of $700 that each party has to pay. And then I get paid. Now it just went up to, I want to say, $85 an hour. When I use up the amount that's in deposit, I have to write a letter to the court saying, court, please order them to pay more. And then they pay more. And once they start paying more, then I can continue in my investigation. Once the case is done, I write a big long motion to the court with my bill that says, I did X, Y, and Z. Here's my bill. Please pay me. The court then orders the county to pay me. The county pays me. And then people have to repay the county. Different counties might work that out in different ways. Some will have the attorney have to collect independent. So they'll appoint the attorney, but then the parties have to pay the guardian ad litem direct. Some will allow the guardian ad litem to set their own rates or have higher rates and have to pay the county and the deposit. Again, it goes very much by local rules. What happens if court orders if the court orders that a guardian ad litem involved but the parents can't afford it? In Brown County, I'll talk primarily about Brown County. I don't know what other counties do because I haven't been a guardian ad litem in other counties. Typically in Brown County, what happens is you can file a petition for a waiver or a reduction of the deposit. They'll look at your income statements, and once you have that, they'll set an amount for that payment. If they put in a payment plan, you have to make the first payment. Then the guardian ad litem can start their investigation, and after that, the county is essentially going to act as the collection agency. Who chooses the guardian ad litem? Can any lawyer be a guardian ad litem on a case? These are two really good questions. Who chooses the guardian ad litem? It's going to depend upon your county. Some counties allow the parties to arrange guardian ad litems ahead of time, independently, and other counties will just, like I said in Brown, they'll have a list, they'll pick off the list, and that's the way you do it. People can ask, but the county will basically say, no, we have a list, you're going to get who's ever next on the list. Can any attorney be a GAL on a case? No. You have to actually have special amounts of credits that you file. So an attorney, to stay an attorney, you have to file something called CLEs every 2 years. I am actually going to be due this year. And when you do your CLEs, you have to, if you're going to be a guardian ad litem, you have to take a certain amount of CLE, specifically CLE credits for the type of guardian ad litem you're going to be. There are two guardian ad litems. There is a guardian, what's called an adult guardian ad litem, and a minor guardian ad litem. An adult guardian ad litem would be somebody who would be a guardian ad litem for incompetent adults. That's primarily through guardianship proceedings. A minor guardian ad litem would be a guardian ad litem in a family court proceeding or in a proceeding affecting a child. Again, primarily custody, but there's others as well. And they will have specialized classes for that, typically put on through the Wisconsin State Bar. And I have to track those hours and report those hours like all my other CLE hours. And there's statutory requirements that I have to affirm to the court that if I'm going to accept an appointment that I have done. Can a GAL look at a parent's mental health records? Yes. Yes, I can. Is that going to be easy? Probably. So the guardian ad litem is going to give you a release that they're going to expect you to sign. One of them is going to be a HIPAA release. If there are mental health records, they're going to say, well, who are you seeing? What's going on? And they'll probably send a letter with the HIPAA release that you signed saying, please release that. And if you say, no, I'm not going to sign that, okay, that's fine. If I think that's super important and you haven't signed anything, I'm going to go to the court and I'm going to ask for an order for that release. I'm going to tattle on the parent that's not cooperating and say, this person's not cooperating and I think they're, I was going to say crazy, but they're not necessarily mentally well, and I think that their mental health is pertinent to the facts of the case. Please order so-and-so to release these records to me, and then I will get the order, hopefully, and then get the records. Let's see. I see Attorney Borcher just said that. I got a good question. Can you? What if you don't like the GAL? Can you request a new GAL? Yes, yes, you can. I think there's a great line in this. I think requesting a new GAL is a bit like requesting a new judge. If you do that, you can do that. And if you don't like that judge or GAL, go right ahead. I think your attorney will tell you that you need to be careful with that. The old saying is, if you're going to kill the king, you'd better do it. If you try to remove a GAL, or if you try to remove a judge from your case and you are unsuccessful and you give a less than flattering argument for that person, they're still a person. They're probably not going to like it, and that might affect your case. So you want to be careful with that. But a guardian ad litem can have conflicts of interest. A guardian ad litem can have bias. A guardian ad litem theoretically could be incompetent or not moving your case forward. So just like any other lawyer, lawyers have ethical duties, and if that guardian ad litem is not following through on their ethical duty, you have every right to go to the court and say, I don't think this guardian ad litem is doing that. I think that they're biased. I think there's this. And personal true confessions of guardian ad litem, has that happened to me? Yep. Yeah, it has. I've had people say that I have a conflict of interest. I've had to call ethics hotlines to say, do I have a conflict? Told no. I've told people, I'm going to have you removed, which I kind of shrug and say, okay, that's fine. If that's what you're going to do, then please feel free to do it. And, suddenly a lot of those tend to go away. So I don't think I've actually had to litigate that before court yet. I suppose I will at some point. It's part of the course with an attorney. One of the most common questions I get asked, can a judge order something different from what the GAL recommends? Yes, I was going to touch upon that. A judge can. Early on, I had stated that an attorney, a guardian ad litem is just like any other attorney. We advocate for a case. Does that mean what the guardian ad litem says goes? No. The guardian ad litem doesn't make findings of fact. The guardian ad litem doesn't give orders. A judge does. Can the judge differ? Yeah, they can. Has that happened to me where I put forward recommendations and the judge goes against that? Yeah, more than I'd like to admit. I mean, it doesn't happen often, but it does. A lot of times, my own personal thing, sometimes I get, I don't want to say aggressive, but I do try to really zealously advocate for my ward's best interest. And sometimes I've had court commissioners and judges pull back a little bit or go in slightly different directions. It happens. And I have my own practice style, and I would imagine every other guardian ad litem has their own practice style. I mean, I've picked up other guardian ad litems works and disagreed. Lawyers disagree. So yeah, judges can differ. Will the GAL always meet with the kids? At what age do kids get to decide what they get to do for placement? um, I'm sorry, I shouldn't laugh. Let's deal with the second question first. At what age do kids get to decide what they get to do for placement? That's called 18. At 18, a child gets to decide what they do for placement. And the reason why is simple. They're not a child. Children don't get to decide where they get to live. That's, why they're in fact children. I've heard a lot of different ages as to what people think they're going to say. It's 12, it's 14, it's 15, it's 10. And everybody thinks once you hit to this magical age, then the child just gets to rule the roost. And if I'm going to dad's, I'm going to dad's. I do think that there's a practical reality, though. Flashback to last week, when we talk about best interests of the child, one of the best interests of the child is wishes of the child. And one of the problems that I always find with best interest of the child is there is no guidance as to which factors are going to be important. It's always going to matter by the child itself. And so you have a situation where courts, in my experience, tend to weight wishes of the child more as they get older. And so a judge is probably going to weigh what the child wants more. If it's a 17-year-old, they're going to put a lot of weight on what the child states than if it's a 7-year-old. I think that makes sense. That doesn't mean the 17-year-old gets a say, though. Well, they get their voice heard, and that voice carries weight, but they don't get to unilaterally decide what happens to them. Will the guardian ad litem always meet with the kids? Technically, no. The guardian ad litem does not have to. It is highly recommended. It's best practice if it does. We have an ethical guideline to, at the very least, lay eyes on the child. So even if the child is an infant, I got to at least look and see that the child has a face, that the child is in fact a child. There's the idea behind that is that you don't want the guardian ad litem treating the child as if there's some academic concept based upon all the facts and reports that they hear, that this is an actual person, that there's some memory, there's some connection between the guardian ad litem and the child. Obviously, if the child is 2 or 3, the input that the child has and the information that they're going to give the guardian ad litem is going to be varied. If the child is, much older, they're more articulate, they're going to have more of an input, they're going to be more of a give and take to that. In my own practice, I like to meet with children after I've met with both of the parents. In my own practice, I know some guardian ad litems like to meet at schools, some like to meet in neutral locations. I tend to like to meet in my office. I like to meet twice, once with mom, once with dad, if at all possible. It's not always possible. Why do I do that? Because I just expect the child to give me 2 different stories between mom and dad. Can the GAL talk to a child's teachers? Sure. Teachers are interesting, I find, because I'm going to do a side venture on this and talk about home visits. Talking to a child, in my opinion, talking to a child's teacher is a bit like a home visit for me. A lot of times I'll get parents ask and say, aren't you going to do a home visit? And I usually don't. And sometimes I get real pushback on this and saying, well, why aren't you doing a home visit? They're expecting me to come in like a social worker and be able to, look at the home and make evaluations and things like this. A guardian ad litem, at the end of the day, is an attorney. They advocate for something. Now, a guardian ad litem means that they have to litigate the case. What does that mean? They have to run the case just like every other attorney. It's generally frowned upon, and it's a terrible idea for an attorney to insert themselves into a case that they are litigating, that they are running. In short, you don't want to become what attorneys would call a fact witness. You don't want to be, if you're the attorney running it, coming in and telling the court what happened in saying, well, the light was green, or the house is a mess, or this. What you want when you're presenting facts, you want other people to tell that so that you can argue about it later. Or more importantly, You want other people to say it, so it's other people that have to be cross-examined by other attorneys. You don't necessarily want to be the one who's arguing, but then also getting cross-examined by some other attorney. That's a generally bad idea, and it's going to almost always be awkward. So a home visit is going to be such where if I walk in as a guardian ad litem and I'm running the case and I look around the house and I see something deeply troubling, what do I do? Do I have to have somebody else come in and look at that house? Will they have it cleaned up by then? Could I use my powers of persuasion to say, hey, you really should change that? But at the end of the day, if I'm trying to arrange a legal case, I can't just go by what I see right away. Otherwise, I'm going to end up in this problem where what do I do? How do I prove it? I know something's wrong, but I can't prove it. And that's going to bother me a lot. And it's going to limit what I'm going to be able to do to argue for best interest of the child. If I'm really, really dead set on a home visit, and I think that's super important, I'm probably going to hire a social worker or somebody trained to observe on that, to be an expert in some fashion, to go in and observe and give me a report. Why? Because I can call that person to be an expert later to prove what my concern is. Same thing with teachers. I can talk to a teacher, and teachers are tricky because they're a separate person, but teachers and sometimes counselors get really funny about wanting to come in and testify, in my experience. Sometimes because of policies of their district, sometimes the bigger issue is going to be teachers and counselors and a lot of these professionals that are meeting with kids. They don't necessarily want to get drawn into the fight between mom and dad. They don't want to be seen as mom's person or dad's person. They just want to be there for the kid. So they'll talk to the guardian ad litem and happily give information and concerns and maybe really, really juicy information. But then they will not back that up in court, which becomes a problem. Because then I have all these concerns, I have these big things, and I need to put it into a recommendation. But how do I prove it in court? And if I can't prove it in court, why am I even recommending it? That's going to be a fundamental problem for me. And maybe I can get around it with other records. Maybe the guardian, maybe that teacher is going to give me some other insights. But unless that person is going to back it up in court, that's going to be a tough thing. Does the judge usually follow what the guardian ad litem recommends? Does the judge give a lot of weight to the guardian ad litem recommends? Yes. Earlier I said the judge doesn't necessarily have to, but the judge gives a lot of weight to it. Really early on I said that the guardian ad litem isn't an arm of the court. That isn't to say that some judges out there don't necessarily see that or don't think that. They do. And the guardian ad litem is a very, very influential person to what is going to be the outcome of the case. So a note about process. A lot of great questions this week. One of I think the $1 million questions that isn't being asked is, what is the process? Because the process here is interesting. When you file a motion to change custody, you'll be sent to mediation, and after that mediation doesn't work, the court will probably appoint a guardian ad litem at that point. There's going to be some situations where you might be able to skip mediation and go right to the guardian ad litem, but that's going to be specific things. The guardian ad litem then investigates best interest of the child and then writes a report. So, and it's called a recommendation. So I saw Stacy asked, does the judge usually follow what the guardian ad litem recommends? Most guardian ad litems will write a written recommendation that will read a bit like what attorneys call a brief. So they'll summarize the facts as they understand them and then apply the law as they see it to those facts. Does that mean that that's the actual? Sometimes people will read that and think that that's the court order and that's the decision. That's not. That's just the way the guardian ad litem sees the case. The guardian ad litem still has to walk in and prove those facts. Whatever they write in that guardian ad litem recommendation, they got to have witnesses and evidence to prove. If they've got the horses and they've got the evidence to prove it, great. If they don't, that's going to be a problem for the guardian ad litem. They have to prove their case, just like every other attorney. Does the judge usually follow what the guardian ad litem recommends? Yeah, and as much as a guardian ad litem isn't going to insert themselves into the case and be a fact witness, a judge is probably going to give that attorney a little bit more leeway, particularly when it comes to wishes of the child, because they also don't want the child to come in and testify as well. So there's going to be some leeway and there's going to be some gray area gray area to that. And the judge does give a lot of weight to what the guardian ad litem sees, because even though I say early on the guardian ad litem isn't neutral, I find a lot of courts are going to see the guardian ad litem as essentially neutral. Since the guardian ad litem doesn't really have a client, they don't have that same sort of focus on a particular outcome other than what that attorney thinks is best. A judge is going to give a lot of deference to the guardian ad litem and a lot of weight to what they recommend. Under what circumstances would you request a psychological evaluation for a parent as a guardian ad litem? If I'm asked by one of the parties, the biggest things when I ask for a psychological evaluation that I'm going to look at, one of the first things that I'm going to do is going to be looking at, quite frankly, who can pay. A psych eval is not cheap, and if I'm in a situation where I'm in a custody battle, that means I'm dealing with two private parties. If I'm in a situation with a CHIPS case, great, let's get psych evals for everybody. You get a psych eval, and you get a psych eval, and you get a psych eval. Everybody gets a psych eval. Why? Because the government's paying for it. And I don't want to be wild with the government's money, but a lot of times the department is asking for this too. And I mean, they're going to pay for it. So if I know who's paying for it, great. Let's get psych evals. Let's find out about what's going on with these parties, especially if mental health is going to be any kind of a question. If I have a situation where I have two private parents, though, that's different. In that situation, I'm going to be a little bit more hesitant unless somebody says, I'll pay for it, or both parties say, we'll both get it done and we'll both pay for it and we'll split it. That's fine. We're going to have to figure out how to pay for this, because I don't want to walk, unless I've got an extremely serious situation where there's very clear mental health problems and I can show that to a court and nobody can pay, but it's very apparent. I don't want to walk up to the court and say, well, judge, I'd like the county to pay for this $3,000, $5,000 psych eval and have the county pay for it. That will not get me a very happy judge or a commissioner. I'm going to have to back that up with something. So I'm going to need a pattern of behavior before I order it. If I have everybody paying for it, then I'm going to look for what are the mental health concerns here. Are people behaving irrationally? What's the communication like between the parents? Is somebody making some really questionable choices? I once had a case where I had somebody with some real mental health concerns, and I had a couple cases like this, where they would get drunk and they would text me or email me angry, and I was the guardian ad litem. It happens again, and in those sorts of things, yeah, I'm going to ask for a psych eval, particularly if everybody is willing to pay. By the way, drug tests are similar to this. If I have somebody who's displaying some really questionable behaviors, I think that there's an AODA concern in this. If there's drug tests, one of the first things I'm going to want to figure out is who's going to pay. If I have an understanding of who's going to pay, then yeah, we're going to do this thing. We're going to test, and we're going to, we'll take hair, we'll take urine, we'll take blood, whatever. I know the labs. We'll get that done. We'll ask for the panels. We'll do what needs to be done for this child's best interest. But I'm not going to do that if I don't have somebody paying for it, unless there's a really, really big concern. I am actually a little over this week. Thank you for everyone for participating and asking a lot of really great questions. If you have more questions about what a guardian ad litem is, or how to even try and work with a guardian ad litem, I recommend having an attorney. And some great family law attorneys are at Peterson, Berk, and Cross. Funny me saying that. You can call and schedule a free consultation with any one of the three attorneys here that do provide family law services, and we'll be happy to talk with you about your case, about how to do that, and we'll even help you. We'll even form that attorney-client relationship with you to advocate for your best interests and your interests in this case. Why? Because at Peterson, Berk, and Cross, we specialize in you. Thanks, Peter. It's nice to hear that. Another guardian ad litem, and I really appreciate the nice job there. So thanks, Peter. And thank you all for joining. Next week, I am going to be talking about, I'll be taking a break from family law and talking about what is a trust. So I am also the estate planner here at Peterson, Berk, and Cross. So next week, what is a trust? So if you've been thinking about that, if you've been on the golf course now and one of your buddies says you need a trust or something like that, tune in next week. We'll talk about what that is and if that's going to be the right fit for you. Thank you much and have a good week.